Hello, I am Stephanie Joy, the attorney at All Things Social Security and Joy Disability Law. Your video is about to start. I just wanted to remind you that if you click the join button below, you can learn more about the memberships offered at a very affordable price that can give you a little more direct attorney answers to your questions. Have a great day and enjoy the video. Good morning. Um, Speaking to you from Niles, Ohio, and I was yesterday in Cortland, Ohio. And a big shout out to the top-notch diner over there. I think it's Cortland it's in. Awesome diner. The food is great. Really had a great time and had some great food. And I actually have the food in my little motel fridge here. But I am heading back to Pennsylvania. But I wanted to bring up a topic. They actually texted me last night as I was tooling around trying to catch up with clients until the wee hours practically, or the very late hours. And it was in reference to, I think it was like a 10-month-old, I'm saying 10-month, I think it was that long, a post, I think it was on Reddit, which I don't frequent, but I have been there and I found it really confusing. So I'm a little too simple for that. Anyway, it was a post about when medical providers just refuse to give patients their medical records. And as you know, in my field, and for many of you, that is so important for your Social Security, disability, or SSI claims. It is important for so many other reasons too, legal and otherwise. So, we have the big HIPAA law that is known by most for its privacy provisions to protect your medical records from getting in the wrong hands or the information. But there's other provisions in there, and I've harped on this. As you know, I have my HIPAA videos that I share as to different access rules in HIPAA that provide patients a avenue for reasonably priced electronic version of their records. When I say reasonable, I mean under $10 per request, which really beats the providers that have been so disgusting over the years with charging hundreds of dollars, or else you don't get your records and then you go to your demise if you relied on them. So anyway, so this fellow, let's call him A. He was interested in cases where, because I brought up the urging that somebody, I would think a newbie lawyer, it could be an advocate. They just can't necessarily fight in court. So that's why I say newbie lawyer. I'm not trying to be exclusive, but that's the way the rules generally run in each of the 50 states. I've kind of urged someone to look into the possibility of a legal field wherein a patient can sue. Maybe it would be small claims court. Maybe it would be superior court. And I'm just using New Jersey state court lingo since that's where I used to practice for about 10 years. Where there is repercussions. And the A's point was well taken. I think part of his point, whether or not he actually said it, was that while HIPAA has this access right, and so it is a violation by a provider to not provide, say, access to the records in the digital form, the way the person wanted them, email, fax, downloaded link in the 30-day time limit at that very reasonable cost I just noted. They are in violation, yet the HIPAA law does not provide for an enforceable practical measure. What it provides for enforcement is the Office of Civil Rights, which is super. However, if you're a patient and your provider refuses your records, you can file the complaint with the OCR, which is quite simple, by the way, and can be done in minutes, very quickly. OCR is not going to go and step up on your behalf against, Goliath. So what they do is accumulate the information. They might send a letter to the provider, encouraging them, we've gotten this report, blah, blah, blah. And I think that will maybe suffice some of the time. But, and then if it's an egregious repeated, at times the OCR then sanctions the provider. That doesn't help the patient in any way, shape, or form in that particular instance. So the theory is that over the course of time, these providers will get on the ball over fear of sanctions. Okay, great. But what does that do for the patient, the individual who's getting screwed? That's why we always, me and some of mine, discuss that there's got to be some way to put bite behind the rule. And just tossing things out there, I mean, medical malpractice would not be the answer for a variety of reasons. However, what about breach of contract? You know, when you sign up with a doctor, there's an implied, a lot of things are provided. Some might even be under some patient bill of rights that maybe some state medical associations, licensing entities require of all of their licensed practitioners. It would have to be looked into individually. Remember, there's 50 states. Okay. I don't even do state law. I do federal. So I'm out of this bucket, but I think someone might want to step into it because particularly, as I said, like a young lawyer who really doesn't know what he or she wants to do, maybe wants to be able to hang their own shingle. It is not going to support you the day you decide to do it. Nothing does. When I decided to step out and do Social Security work 20 years ago, I had to do other work to pay the bills. I mean, fortunately, that changes when you put in, a decade of time, but you have to do what you have to do to pay your bills while you try to build your creation there of your practice. So, but what about the breach of contract? It can be implied terms of the contract, like they're not in that document you sign when you sign away your life every time you go to the doctor. They're not certainly, uh, signing away anything. But there are implied, and there's laws, common laws, regarding implied terms in contracts. It is a legal thing. So it could be under the basis of that. What would be an implied contract term that all patients expect and believe that a doctor agrees to when they take them on? Oh, you're not going to abuse me. You're not going to molest me. You're not going to do X, Y, Z. How about you're going to be honest about my medical condition? Probably another area is not doing incompetent recording of medical histories, patient complaints, etc. That's a whole nother thing. Um, a whole nother thing, including the fact that the computer programs, while they help in some ways, they hurt in some ways too, with regard to that cutting and pasting, hint, hint. So I think there could be a breach of contract. Certainly if, I'd like to see, and I say I'd like to see, this doesn't mean I'm going to be practicing this area. I'm throwing it out there because I think somebody should. And if I were a young lawyer, not at the end of my career, but at the beginning, I'd be hopping all over this. But that's who I am. That's the kind of personality I have. But there's got to be others out there that are interested in finding a niche. And this might be a place to look at a cottage industry, since it doesn't seem to exist right now. I was also telling A that while I'm not the one to do the job, I just got the ideas. I have a practice and I have a million-hour-a-week work week. But if it would be like a cottage industry, certainly, but I really think it can be done. And I think there are legal principles out there already that support it. Breach of contract is the one that just came to my mind. And small claims court is where even patients who don't have attorneys can go to for things. And I think this could be something that could be well developed. And it would put, I can't even imagine the medical providers or their corporate profit makers going frantic over having to go to every little town's small claims court or county and handle these things. Again, it's not for the big. It is not for big monies. That is not the point. And generally, most people who aren't getting their records timely don't necessarily lose big monies. Some do though, like the people that I work with, if we don't get them. So it wouldn't be lawsuits for big monies. It would be lawsuits to get them to hand over the records so the lawsuit goes away. That's pretty much it. And maybe you have to pay the attorney fee if you hire an attorney. I know that another federal law, Federal Debt Collection Practices Act, I think, has an avenue where if a lawyer steps in to help a person who has been screwed credit-wise illegally by, false reportings to credit bureaus and such, the law there actually says lawyers can take this niche. That's another niche I had been looking into years ago, but then I went full throttle with SSD, SSI. Lawyers, it already expressly says that attorneys' fees or legal fees, I think, are included as a winnable remedy. And a person that has been violated under the FDCPA can file suit and get as part of their damages, not just say $1,000 for every lie that was told on a credit report by somebody, but they can also get an award of attorney's fees. And that is what makes attorneys jump on those things. And I'm not putting attorneys down. I mean, I'm one of them. But yet, you can't expect attorneys to give up their entire lives and have their house foreclosed to do something that is morally beneficial to others if they're not going to be able to pay their bills and their family's going to starve. You wouldn't do that for yourself or your family, so you can't expect them to. So that whole idea up with the FDCPA, and I hope I'm saying that right, is something that I think needs to happen with HIPAA access. And maybe other areas in HIPAA, but I'm only referring to HIPAA access here and those rules. So anyway, that was what was going on last night and then this morning. And I have to thank A because it is a really important topic. His expectations of me being able to suddenly give up my practice and go do it at my advanced age is not going to happen. But I certainly would be happy to talk to anybody who wants to delve into it. I would contribute. I'd be happy to contribute. I think a change needs to be had. Anyway, all right, that was it. That's exciting. I am leaving to go back to Pennsylvania, hitting the road. I'm in my motel room, and I'm getting off a little late here because it's already 8:30. All right, I'm out of here. I'm on for my 5-hour drive. I'll talk to you guys later. Bye.